This is a video on conflicts of interest, and it's a serious problem in bankruptcy and comes up quite a bit. The issue comes up when a lawyer wants to represent a debtor, but the lawyer also represents creditors of the debtor or has represented creditors in the past. The same thing is true for a lawyer that is vying to represent a creditors committee. It's also true for lawyers who represent multiple creditors in various situations. One persistent issue for lawyers is whether, as a lawyer, you can represent multiple clients related in the same case. The benefits of representing multiple clients can be enormous and indisputable. First, a lawyer can share costs for duplicate work. For example, a lawyer can share research costs or the cost of hearing attendance among many clients. Obviously, these costs can add up very significantly. There may be other benefits as well. One plaintiff with many defendants may be more inclined to negotiate if challenged by a group than a number of individual defendants. In other words, it can remove plaintiff leverage and create leverage for individual defendants. On the other hand, the lawyer must be scrupulous in identifying any conflicts between the clients. What if there is no current conflict, but the lawyer could foresee a time or an event where there would be a conflict? Should she give up representing more than one of these clients? What exactly should she do? The courts are actually divided. Some recognize the difference between so-called potential conflicts and so-called actual conflicts. Other courts rule that any conflict is an actual conflict. There's really no such thing as a potential conflict. Courts that do allow representation of multiple clients when there is a potential conflict require that the lawyer disclose the potential conflicts to the clients and obtain approval. But how exactly should the lawyer disclose the conflict? In Anderson v. Nassau, a Eastern District, New York 2005 case, the district court faced these questions. First, the court cited and adopted the so-called per se rule, which states that there is a presumption that an attorney cannot represent multiple clients. However, the district court also found that this presumption is rebuttable by evidence that there will be no actual or apparent conflict in loyalties or diminution in the vigor of representation. Additionally, the court found that an attorney faced with a potential conflict must disclose the conflict to the client and obtain written approval. Further, the disclosure must articulate exactly the implications of the potential conflict. In this case, the attorney was late in disclosing the conflict, and the disclosure was not sufficient to meet the disclosure bar. Disclosures of conflict and consent of clients should be made before undertaking representation. Recently, the bankruptcy court for the Second Circuit faced a potential conflict situation in a similar issue. The court, in black and white stripes, 2020, opined that there is really no dichotomy between potential and actual conflicts. Instead, there is a continuum of conflict situations from harmless to egregious. The court opined that a better test is whether the facts are such that a lawyer would be swayed by a meaningful incentive to act contrary to the best interests of the estate and its creditors and place them at more than acceptable risk. In that case, the court found that the conflict was serious enough that the lawyer was indeed swayed or could have been swayed. The Fifth Circuit has taken a little bit of a different position. In INRI WF Development Corp., Fifth Circuit, 1990, the Fifth Circuit found that any conflict, potential or otherwise, militates the withdrawal of the lawyer from representing multiple clients. In that case, the attorney represented both the general partners and the limited partners in a bankruptcy proceeding. The court found that there would always be a potential for conflict when one attorney represented both limited and general partners in a bankruptcy, making disqualification proper. The court's rationalization was that any conflict had the potential to become actual at any time. The court decided that even with an absence of findings of fact, a potential for conflict arose in such case of dual representation of both the general partner and the limited partner. Currently, the First, Second, and Third Circuits hold that the relevant rule is whether the potential conflict is strong enough to influence the representation of the lawyer in favor of one client at the cost of another. What kinds of facts are potential conflicts that merely require disclosure and client approval? In Intervest Business Equipment, the 10th Circuit tried to answer that. The attorney represented 3 bankruptcy estates in the bankruptcy case. In this case, the 10th Circuit observed that the existence of a pre-petition debt from one estate to the other was an impermissible conflict. The court ruled that the facts resulted in mandatory disqualification of the lawyer from representation. In Tri-State Financial, which is an 8th Circuit 2008 case, the attorney, who already represented an unsecured creditor, requested the court to be appointed as the trustee's counsel. The attorney disclosed that he represented a creditor and that no actual conflict existed at the time of the employment request. There, the Eighth Circuit opined that disqualification was not necessary. The takeaways from this video are twofold. First, a fairly clear answer on whether an attorney can represent two or more parties that have so-called potential conflicts depends on the circuit. Second, even if the circuit precedent seems to permit representation of multiple parties when there's a potential conflict, the courts will undertake a deep factual analysis to decide whether the so-called potential conflict was sufficiently or is sufficiently egregious as to not permit representation. And in the Second Circuit, whether there is any likelihood that the conflict could sway the attorney to favor one client over another client. Lastly, in any circumstances where a court might permit representation of multiple clients, where there are potential conflicts of interest, the attorney must provide written notice that explains in detail the potential conflict and all possible implications of the potential conflict. Lastly, the attorney must obtain written approval from each client that the attorney may continue to represent multiple clients despite the potential conflict. Every attorney has a duty of loyalty to zealously represent her client. There are situations where the potential conflict is far off and unlikely, and the benefit to the client of multiple representation clearly outweighs the danger. Nonetheless, the attorney proceeds at her own peril and must take great care not to cross this murkiest of red lines.